All right. So I want to start by saying a very warm welcome to Anne Butenhoff. Anne is an attorney and she is here from Sheehan and Finney. And originally, she is a co-founder of the Butenhoff and Baumster agency. So she is somebody who's been in the legal world and has specialized in this area for many years. And she also is somebody who has become a resource to different organizations around New Hampshire when it comes to talking about the legalities around guardianship and trust and other elder care issues. So I'm going to highlight some of the elements off of her bio so that you all get a sense for the great work that she's done in the past. She is somebody who, in her early work, represented the nonprofit, the New Hampshire Legal Assistance, NHLA, representing low-income and elderly residents, and has a strong appreciation of the special legal and care challenges facing New Hampshire residents. As I mentioned, she's well known across the legal community for this expertise, especially in navigating Medicaid, eligibility rules, public benefits programs, and special trust needs. Anne specializes in estate planning, elder law, and planning for the future care and financial security of children with special needs and individuals who have disabilities by tailoring estate plans to protect life savings while maintaining eligibility for needs-based benefits programs, which is kind of music, I think, to many of our ears as we think about the things we've talked about in our support groups. In addition to working directly with individuals and families, she is a trusted legal resource for financial planners and fellow attorneys in her practice areas. She's also been asked to train on these topics. So this is something that she is out in the community helping to advise on. And just for those of us who have been with NAMI for a while, you may recognize Anne's name because she was also a past board member for NAMI New Hampshire. So Anne, thank you so much for giving us this time and for sharing your expertise on these important topics.
You're welcome.
So what we wanted to do is we want to start with some of the questions that have been submitted. And I'm going to start by teeing up the conversation of guardianship first.
Okay.
And what I'll start with is for many of us, as we've been having support groups, we often find ourselves as parents or caregivers really facing a challenge when our loved one is sort of stepping into areas where we are finding ourselves lacking control. So they might be hospitalized, they might be making poor decisions in their lives, and we haven't in the past been able to gain guardianship. So some of us, when we get into that state, find ourselves saying sort of, what do I do now? What are some of the first steps I need to do? How do I even step into this world so I can help my loved one, even though they may not want my help? So I'll turn it to you just to talk about kind of how do we get started, and then maybe talk through some of the different forms of guardianship that are out there.
Okay, good. So this is a super difficult topic, and because there is not a good answer that for everybody. From what you said, it sounds like there have been prior efforts to get guardianship. They were denied, and now they're in a new situation and they really could use that authority. So that's a tough one. Let's go over what you have to prove at a guardianship hearing. I mean, just to what does it mean to try to get guardianship, and what's going to, how do you convince a court that this is the way to go? So a guardianship action is an adversary proceeding. You're filing a petition against someone. It sounds awful, but you're saying they need to be declared mentally incapacitated. That step by itself is very scary for a lot of parents to think, they don't want to have that determination, especially by a judge. But it requires filing a petition. You have to lay out allegations like why do you think this person is not safe to themselves or safe to others? Can they take care of their own housing and food needs? What's happening with them financially? You've got to figure out what is your basis for saying that they need this help. And then after you file the petition, the judge will appoint an attorney for the proposed ward. So your child becomes a proposed ward. the attorney's job is to fight the guardianship if that's what your child wants to do. And whether it's to stop it from happening or to limit the reach of it. But the attorney has a very specific job, and the New Hampshire statutes, like most states, give a proposed ward the right to legal counsel. And so, and it makes sense if you think about yourself, you know, if somebody is going to take away your right to make these decisions, those decisions, where you live, what medical concerns, if you just put yourself in that position, you can see why it's a hard process. We don't want to make it too easy, you know, or my husband would go in and try to become my guard, you know, make decisions for me. So, so it's a hard thing. After the attorney is appointed and meets with the proposed ward, there is then a hearing, a court hearing. And if the proposed ward doesn't want guardianship, then you have to prove your case with testimony and evidence. So one of the things that I always think about when there's a potential contested guardianship is, who do you have to testify? Who's in your corner? Who's going to get, who, is it just you? You know, it's hard, as you know, to say in open court in front of your loved one all the things that are wrong right now, and why you're so worried, and what they have done, and making it's not going to be public to the entire world, because guardianship hearings do have confidential rules about them, but it's very public just to be in the courtroom. And but there also might be friends, there might be neighbors, there might be other relatives who could testify. If you have doctors and, you know, nurses who are able to, you know, testify, that's good too. One of the things that Deb had mentioned to me is you can't always talk to the doctors, right? You don't even, because there isn't guardianship in place, you may not be able to gather any information whatsoever. I think that when New Hampshire Hospital sometimes will bring guardianship actions, you know, they have access to the doctors right there. You know, they're in a much different situation, but I have experienced times where you know, doctors do testify, not necessarily in mental illness situations, but I've seen it in dementia cases. And I don't think that the confidentiality rules change depending upon what's going on with your brain. I think it's the same. So, but I think in the mental health arena, therapists are very protective of their clients. And, you know, they've got to, you know, they've sworn to keep things secret. So it's a hard situation, but they're, yes.
Can I ask a question? And I just want to ask it while it's fresh in my mind from the topic that you're just mentioning. Knowing that it may be difficult to access medical professional care from as far as testimony, is it possible? Are there examples of types of tracking evidence that might be used in testimony that you would suggest that people are aware of? So what are some of the best things that they could do to prove their case if they have to make that tough decision in court?
Right. So the focus of the judge is going to be on providing some very clear examples of how the person's mental processes are impacted. So you got to give real examples. So I know people that keep logs, you know, just because then you can go into court with a log and you can say, yes, I kept contemporaneous records of what occurred. I imagine some people have calendars that they write things on calendars. But there's also, I'm assuming, this could be a wrong assumption, but I think some of you probably have had to call police or know that police have had to be called with respect to your family member. And police records you can obtain. So that's something to think about as well. But you do want to focus on how they are not taking care of their own health and how it's impacting them. So they're focusing on health, they're focusing on shelter, they're focusing on food, they're focusing on money. And many of your family members might be easily taken advantage of. How do you prove that? Well, they just gave away, $200 to so-and-so who they didn't even know. I'm sure you can think of, you understand what sort of examples I'm talking about. So you do want to keep track of them. When you file a petition for guardianship, you can mention things that happened a year ago, but the judge doesn't want to hear about it. The judge wants to hear anything within six months. Everything should be within 6 months. And there has to be examples within the last 20 days. So that's something to think about. You want to have current examples. Now, when things are bad enough that somebody has been involuntarily admitted to the hospital, the New Hampshire hospital, that's kind of a good example of what's happening now. So that may be all that you might need now to go into court and say, I'm piggybacking on the fact that there was this involuntary admission. He's now in the hospital. This is why he or she is in the hospital. This is what led to it. This is why everyone's concerned. So, does that answer your question, Deb?
That's very helpful. And I've been taking notes as fast as I can. So that's exactly the kind of information that we're looking for. Perfect. And there is another question that came up that was submitted by one of our participants. And I just wanted to, you let me know if this is better for us to save for when we talk about trusts. But
Sure.
it says, I'd like to know more about how difficult it is to obtain guardianship, which I think you just covered very well. And then it says, and the requirements as well as info on Medicare in terms of supplemental insurance. If that's something that you could speak on, it would be great. Her loved one is on both Medicare, Medicaid and Medicare, and some places don't take it. So I have to get additional insurance. So is that better to talk about when we talk about setting up more financial arrangements?
I think that public benefits, honestly, Deb, is a huge topic.
Mhm.
And I do have a lot of knowledge about this, and I can touch on it.
Great.
But
it's a little off our course.
It's a little bit off the court, but when you're applying for guardianship, the guardianship paperwork will ask about streams of income and assets. So, if the person is on Social Security disability insurance or supplemental security income and what that monthly amount is, that is going to be stated, as is, how much money is in the bank, if there is any in the bank. They don't ask about health coverage, but those things are really important to bring up at some point, not necessarily at the time of guardianship. What guardianship would give you is the ability to interact with the Department of Health and Human Services with respect to Medicaid, and the ability to interact with the Social Security Administration with respect to Medicare and Social Security payments. So guardianship, well, actually, Deb, I didn't talk about the types of guardianship. So there is, if you think about yourself in terms of split into two categories. One is health, your person, who you are, where you live, what your health is, and your finances. That's your estate. So the guardianship, when you're filing, you're either filing for guardianship over the person, guardianship over the estate, or guardianship over both. And you're also applying for either temporary guardianship or lasting guardianship. You don't know if it's permanent, but that's essentially what they're asking. Are you asking for this to be a 90-day thing, or is this indefinite? So, so I thought that was important to cover, that you're going over one or the other. The other thing that you brought up, Deb, right before we added everyone on, is if your loved one is at a time in their life where they're open to ideas and your help, this does happen periodically, maybe they would be willing to sign powers of attorney at that time. Maybe they would be willing to sign HIPAA releases at that time. HIPAA releases are what would give you the authority to talk to medical professionals and obtain information. A healthcare power of attorney really only provides help for you when the person is deemed to lack mental capacity, and mental illness is a hard one with that. It's easy when you're under anesthesia, or you've had a real bad, car crash, or those situations, the doctors are very familiar with declaring that somebody now lacks mental capacity. But in the area of mental illness, there's a spectrum, and when do you say that they lack it? So, but the healthcare power of attorney doesn't have any relevance until that's done by some medical professional. So the HIPAA release, it at least gives you the ability to talk to doctors. The financial power of attorney would extend to being able to handle any sort of financial matters for you and enter into contracts on your behalf and deal with, it's pretty broad. Now, the other thing Deb and I mentioned is that these documents are, they're revocable, right? So if you're having a good day and you sign these wonderful documents, and 2 months from now you've deteriorated, and you're not taking your meds anymore and the like, many people decide that nothing's wrong at that point, and they might get extremely paranoid or whatever, and just decide, yes, I gave you authority before, but now I don't trust you. Now I'm taking it away from you. And they tear up the documents, they revoke the documents, and then you're back to square one. So, but the idea behind powers of attorney is that it's a way for them voluntarily, for anybody, all of you should have these in place. While you have mental capacity, you voluntarily choose who's going to make those decisions for you, who's going to help. And so you're not waiting for a court to make that decision for you. You're doing it for yourself. And it is a lot less restrictive than a guardianship. It's not as heavy-handed, and sometimes you can really help people a lot with those documents in place. But it often doesn't help when the person is suffering from paranoia or any other situation where they just don't trust you. They're in a different reality. They might be hallucinating. You know it a lot better than I know it.
Absolutely. And I think that's so important. And I just really love the reflection back on, we taking advantage of times when we're not in crisis with our loved ones to have some of these conversations where we're able, knowing very well that for many of us, some of those conversations aren't even possible, even during the calm times, because we have people who don't even fully embrace the fact that they're struggling with mental illness. We had a question from the group that, or from one of our participants, that said, one point that can be challenging is if our ward doesn't want to embrace this guardianship, we likely already don't have access to their finances. So does that make it even more difficult to get guardianship if you go in and you try to fill out the paperwork and you don't know what their true financial situation is?
Well,
How,
that's interesting. I mean, the answer, there's no answer to that, because I think it all depends upon what your other facts are.
Mhm.
But you could easily say, this, this person is so distrusting that nobody knows anything about their finances. However, I did, the last time I was in the house, I saw that the utility bill hadn't been paid, and there are examples of not paying the rent, not paying utilities, not keeping up with things. But you may not even know if they're receiving income, in which case you say you don't know. And once you're guardian, you'll have authority to figure it out. So there could be many people who have never wanted to be declared disabled. They don't want to get on Social Security disability. They don't want to get on supplemental security income. So they've never filed, an application, and you don't have authority to do it on their behalf. They have to participate in that. I mean, you might be able to start the paperwork, but you really won't be able to finish it without their participation, and they'll have to see doctors and, get evaluated. So.
Okay. Another really good question came up from
Just getting Kleenex. Yeah.
oh, sure, no problem, from one of our participants. And that question is, what are my legal responsibilities as a guardian? My sister recently expressed an interest in wanting me to step in as her guardian. She does waiver, just like you were talking about on that, when her paranoia is worse. I believe I'm already performing many of the duties, but I just want to understand, kind of in general, are there some standards around what the expectations are of a guardian? And I guess that would point back to the different types of guardianship that there are.
It does point back not only to the types of guardianship, but the breadth of the guardianship. So in the guardianship petition, you are asking the court for authority over certain things, and it has there are check boxes, like a long list of check boxes. Can this person drive? Can this person, you're just going through and saying, I need authority over everything, or is it targeted? I need authority over bank accounts. I need authority over medical decisions. You can find these forms, by the way, on the probate court website. If you just Google New Hampshire probate court forms, you will find it. And under probate court, there will be guardianship as well as probate as well, so you want to go to just the guardianship piece. And but all the forms are there, and you can look through it to see what it is. Now, the judge is supposed to try to impose the least restrictive, make it as less broad as they possibly can. And of course, the attorney for the proposed ward is also going along those lines. So when you fill out this form, I would recommend that you not just check every box unless it's really necessary. When I've seen that necessary is with other types of disabilities, the child with very severe developmental delays who really won't be able to make any decisions on their own. They just can't do anything on their own. So you're in. The other thing I should tell you is, even if you get guardianship today, it doesn't mean that this is forever. There could be breakthroughs in treatment. The person could do super well. You can go back into court and ask that it be terminated. That means that the ward can ask to have it terminated, but you can support it or not support it. So it's, this is not for the rest of this person's life. One of the things for you to really think about, going over what is your role? It's often needed when you're being denied access to certain things. Like, if I try to make a call on someone's behalf and they just won't speak to me, and the person won't do the calling themselves. Sometimes you're managing very well for forever. So I spoke to someone today. It's not a mental health issue, but it's close. This person is 54 and has very significant autism. I mentioned this to Deb, but his mother died recently, and he had always lived with his mother, and his mother never got guardianship over him. His mother just, did all this stuff for him all along the way. Now he's living with his sister, and his sister's saying, I can't do I'm not being allowed to make medical appointments. I'm not being allowed to, to do this and to do that and the like. She's in a lucky position in that even though she doesn't have this authority now, her brother will gladly grant it to her. So that's a very different position than many of you will be in. But my point is, he's 54. He's needed assistance forever, but somehow the family member got along all this time without the official document of a guardianship. And so in terms of the person who asked about the sister, you have to think about, well, why do you need it? Could this person just sign powers of attorney and give you the authority that you need? Do they have enough mental capacity to sign power of attorney documents? And if so, maybe that will be all you need to do. But if there are other things happening, then you want to step in. One of the questions asked of me today with respect to the sister for the autistic person is, what if my brother gets in a car accident while I'm guardian? Am I legally liable? And, the answer is no, not really. Now, if you give the person who doesn't have a driver's license a car, that's a different question, right? But if you're just in the role of guardian, you can't be with that person every minute. You can't, it doesn't mean that you're going to have total control over everything that this person does. That, you just won't. But you have to determine, well, what do I need the authority for, and how will it help me help them? And so I guess that's how I would answer that question.
That's such an important point. I think that's such an important point. And I'm going to bring us talking about, that idea of caring for our loved ones for the long term. I'm going to shift our thinking a little over to trust. So we can spend a couple minutes at the high level talking about the future of our loved ones. And for those of us who are caring for adult loved ones, and we might have some worries about what's going to happen after we pass. Let's kind of shift into that world for a few minutes. And there have been some great questions also building up in the chat. So I just want to reassure everyone, we'll talk about trust for maybe about 15 minutes or so, and then we'll go through some of the questions in chat and open it up for everyone to ask their questions as well. So, so do you mind, Anne, just sharing? I think one of the scenarios is that we commonly hear is just that concern over our loved one just cannot get their life together, and I want to make sure that they're taken care of after I'm gone. Are there some initial steps that people can take? How do they get started in that world?
Right. So, and I think what you're saying is that they shouldn't receive their entire inheritance outright, or it'll be gone. So somebody needs to be appointed with the authority to manage money on their behalf. That's the direction you were going, right? So
I think it's like even just options. Like, so if I'm thinking about, like, I just need to make sure I'm setting up a future for my loved one, how do you even start that ball rolling? And what do we need to think about with that?
Well, I do think everybody needs to have some form of an estate plan for themselves. And that involves planning for your disability. You might lose mental capacity. You need a healthcare power of attorney, and you need a financial power of attorney. Those are estate planning documents for, your lifetime. They have no significance when you die. So if you're thinking about death, then you either are focusing on a will, which by definition is going to go through probate court and be overseen by the court system. And you can have a trust written up. You can have provisions in the will of any sort that you want. But if it's an ongoing scenario where someone's going to be managing money for somebody over time, in New Hampshire, our courts will not give up jurisdiction of those. So that's going to be in forever court overseen trust. The way to avoid probate and the way to have privacy and have it taken care of outside the court system is to have some sort of a trust mechanism. And I don't know how many of you know anything about trust, but there are, this is very simplistic, but there are three general roles in a trust. There's a person who creates it and puts money into it. In our firm, we call that a grantor. There's the person who has the legal authority to manage the money. That's the trustee. And then there's the person who is benefited by the money, and that's the beneficiary. So there are many, many kinds of trusts. But if you're just doing a run-of-the-mill trust to avoid probate, you would be creating what's called a revocable trust. You're putting your own money into it, and it's going to be, it's going to run during your lifetime and then run after your death, explaining how things are handled. I would be the grantor, I would be the trustee, I would be the beneficiary during life. So what the trust does then is set up successor trustees for either if I lose mental capacity or I die, and successor beneficiaries, children, other loved ones. So in that trust, you can set up, well, what's going to happen with this person's share? So you might have 3 children and you can say, Johnny and Susie are going to get their share outright, but I'm very concerned about Tommy, and his should stay in trust. And let me give you some guidance as to how. Oh, I'm sorry, but my dog wants to say hello.
We love when dogs visit.
All right. Well, this is Wicket.
Wicket, what a great name.
Yeah. So we thought she looked like a Star Wars Ewok. So
adorable.
So a trust is an important mechanism for trying to avoid probate. When you create a trust, the act of creating it does not avoid probate. The trust actually has to own assets that can be titled. A house can be titled, that's by deed. A car can be titled, that's by, deed. Bank accounts can be titled. So, you're going to your bank and you're changing them to, from Anne personally to Anne as trustee of Anne's trust. So there are steps you have to take in terms of knowing your own assets. And I should tell you, by the way, it's important to know your own assets. And I don't say this lightly, because I've helped a lot of people with Medicaid applications when there's a nursing home admission, and I'm surprised by the number of people who we discover an asset they forgot they had. And it's because of our review of their records that we see it. But it's good for you to really organize your own personal finances to know, what do you have? How is it titled? You might be married, you might not be married. How is it titled? If there's a beneficiary, who is it? And this is something else I should mention to you is a trust is not the only thing to worry about, because many of you have IRAs, 401ks, assets like that, and they have beneficiary designations, and you might have named your child as a direct beneficiary of that asset. So as you're doing your planning, and if you've decided that person really should not inherit anything outright, especially that kind of an asset, maybe what I need to do is create a trust and have, make the beneficiary the trust. The question was raised about public benefits eligibility. There are some public benefits that are highly important to people that have financial eligibility criteria. So Medicaid is a good one that has financial eligibility criteria. There generally are resource limits. There are certain programs without resource limits, but historically they've all had resource limits and then income limits. So they're on that important benefit now, and if they inherit $10,000, boom, they're off, right? So what are we going to do? And then there's supplemental security income. Supplemental security income is overseen by the Social Security Administration, but it is not Social Security. There's Social Security disability insurance, which is tied to a work history. So I'm working, I pay into the system. If I become disabled, I get Social Security disability insurance. I then will get Medicare after I've been on it for a couple of years or when I retire. So I'm paying into a system that covers my retirement and my disability. It also provides coverage for some people in your family, like a spouse, but also if a child was disabled before the age of 22, then they may be able to get benefits on your work history. This is known as Children's with Disabilities benefits, so CDB benefits. And this can be kind of a game changer when you've got a child on SSI that has all these strict income and resource limits. You then retire, your child who was disabled a long time ago at age 22 can now start receiving SSDI on your work history. The children disability benefits is like Social Security disability insurance. So the important thing about SSDI or Social Security disability insurance is that there is no resource limit. There is no unearned income limit. There is an earned income limit, because if you go out and you're able to make a certain amount of wages, by definition, the Social Security program says you are not disabled any longer. But the reason that this unearned income limit is important is that if I give you money, I deposit money in your bank account and help you out financially, those dollars are considered unearned income to you under both supplemental security income and the Medicaid program. So you don't have to worry about that with SSDI. You don't have to worry about that with Medicare, but you do have to worry about it with these other programs. So the first thing that's important is for you to know precisely what public benefits are at stake. And whenever I meet with somebody and they'll tell me what they're on, I don't take their word for it. I want the actual documentation to show me, because people mix it up all the time. Medicaid sounds too much like Medicare. SSI is only missing the letter D. It sounds like SSDI. People mix them up all the time. So it's important to see what those are. So where I'm going with this is that if you are trying to think about planning for somebody who is really dependent on these public benefits or benefiting from these benefits, then you want to make sure they're not going to lose them. So this is a little bit different than saying Johnny is not good with money. This is saying Johnny can't receive money or it will negatively impact Johnny, if you see the difference. And for that sort of planning, the type of trust that is generally created is commonly known as a special needs trust. And when I create it for my child and I'm going to put my money into it when I die, that is known as a third-party special needs trust. Why is that important? Well, that just means that it was never my child's money. So they didn't inherit the money outright. If I left the money outright to my child, then my child would be able to put it into a special needs trust, but then it's a self-settled special needs trust, meaning he's taking his own money, putting it into a trust. And that kind of trust must have what's known as a Medicaid payback provision, which means if any money remain at the end of the day, it pays the Medicaid program back. So generally speaking, when you're planning for your own money, you don't want to have a Medicaid payback provision, and you don't want to knock somebody off public benefits. So you're going to create a third-party special needs trust, and that's where you're going to direct the inheritance. Any trust is going to require somebody managing the money. If there's enough money, then you can be looking at the possibility of some type of a corporate trustee, whether it's a trust company or a branch of a bank. They generally are looking for, at least $1 million under management. So it's not available for many, many people. So then you're looking at family members, friends. Who else do you really trust to manage this money properly? The only beneficiary of a trust the only beneficiary should be the child that has a disability for either one of these trusts. You want it to be clear that this is Johnny's trust, and there's more than one way to do these things, like everything. But our office prefers to create a separate trust document, the third-party trust document with Johnny's name on it, essentially, and identifying it as a third-party trust. That increases the cost of doing estate planning, because you're creating a revocable trust. Now you're creating the separate third-party trust. Why would you do that? The only reason, and you don't have to do it this way. The reason I like to do it that way is you're dealing with bureaucracies reviewing these trust documents. So whenever there's a trust benefiting somebody on SSI or Medicaid, and there's money in that trust document has to be given to the Department of Health and Human Services for Medicaid or the Social Security Administration for supplemental security income. I personally want to make it easy for them to review the trust and see what kind of a trust it is. And so that they won't count the money as belonging to that person. So, and they won't, that they know that there doesn't have to be a Medicaid payback provision. So there are things that I want them to identify the beneficiary. I want them to identify the type of trust it is and what the terms are. That's covering a lot of ground.
And this is incredibly helpful, and also very much proves the importance of having a good attorney in your life, because there's a lot of layers to this, and it's been very eye-opening for me. And I think some of our members here too, that, we have ideas about this, but there are so many steps that need to be taken, and they're so important if we want to make sure that our loved ones, especially those that might be receiving benefits, that we're handling the future in the best way possible. So
the other thing I do want to say about picking a trustee is, when you're dealing with mental health, I think it's very difficult to name a sibling of the person with a disability. And it's hard enough to be a sibling of someone with schizophrenia, just to have that relationship and manage that relationship. But then to be in control of the money and to decide what gets paid or not paid or when distributed or the like, it can just be awful. So to the extent you can find something else, and there are possibilities of having nonprofit organizations serve as trustees, and you may have heard of pooled special needs trusts, and New Hampshire has Enhanced Life Options Group, but then there are many national organizations that also do this work very well, even in New Hampshire. And that can be a professional organization that serves as trustee. They don't have a minimum amount that has to be under management. Some of them will not allow the trust to own real estate, but they don't have a minimum on anything else. So you have to give careful thought to trustees and how this is going to play out with a sibling. And when we do special needs trusts, we include a fourth role, which we call a trust protector. And that's often a good role for a sibling because you're giving that sibling the authority to be an advocate for the person. That person can get copies of accountings. That person can ask for distributions. That person can fire the trustee and replace them. So there is kind of like a check and a balance on the trustee. So there are different roles for siblings if you can think about it. Think about that. Now, I want to quickly mention ABLE accounts.
Yeah.
So ABLE, ABLE, stands for Achieving a Better Life Experience. This is a federal statute that came into being about 2012. New Hampshire's had a program a few years after that. They've just revamped their program and how they're operating it. But there are some super good things about ABLE. The money in the ABLE account technically belongs to the beneficiary, which would be the child with disabilities, with mental health issues. You have to have been disabled before the age of 26. You can self-certify. You don't have to have proof that you were on Social Security disability by 26, but you were disabled by 26. But the money in that account does not count towards the Medicaid resource limit or the resource limit for supplemental security income. There are limits as to how much money can go into these accounts every year. Right now it's $18,000 per year. It can grow to a very large number. You can be in charge of that account and you can preload the equivalent of a credit card, a debit card. So you're preloading it and you can act as the only person who's authorized over it. Those accounts can also be used to buy food. Those accounts can be used to pay for shelter. And the reason that's important is that supplemental security income and Medicaid both say if somebody helps you with providing free room or board, we're going to consider that in-kind support and maintenance or a different type of unearned income, and it will lower your SSI check, and it possibly could affect where you are in your Medicaid eligibility. So food and shelter, if it can be paid for by the ABLE account or paid for out of the individual's income, that's better than even using a special needs trust for those.
That's fantastic. And that was one of our questions that was submitted too, was about the ABLE account. So thank you for touching base on that. And there are a few more questions that have come through in chat. So I'm going to just take a quick look because there's some really good ones here too. And we are down to about 9 minutes left. So I'm going to go back. Bear with me one moment. So going back to guardianship, one of our participants was talking about the benefit of the OPG that had come in to support when her loved one was at New Hampshire Hospital.
So let me say this about the Office of Public Guardian. They're great. They don't have enough money. And I have 2 clients now who have been waiting for over a year for a guardian through OPG. And they've been approved. They've been determined eligible. One of them has a sister who's 81 living in another state, and she just can't keep helping him through a power of attorney. It's not working anymore. She's been waiting for over a year. And another person is the guardian of their son who has mental health issues, and the 2 parents are they're ready to just be parents again and not be the guardians. So not only do we have a problem with OPG not getting enough funding, but we don't have enough private guardians. So on the probate court website, there are a list of individuals who will serve as private guardian. They've been vetted by the court as having the requisite skills and the like. There's none of them as of today have any capacity to take on another client. You know, we really have a serious problem in New Hampshire about someone other than a family member as guardian. And the Office of Public Guardian has a new executive director. The one who'd been there had been there a long time. Her name was Linda Mallon. She retired. Lisa Britt-Solsky has stepped in, and she is really driven to see about getting more funding, because she's just seeing how difficult this has been for people. But that's so it's a great point. OPG is great. I wish I could place many people there, but I can't.
And that makes sense. And it's a shame. It's so common with so many things in the healthcare industry, especially the mental health care arena, that we have lack of services and lack of available personnel to help support it.
So I imagine that there may be times to be able to appear in front of your legislature to testify as to what an important thing this is. It's not right now, but there may be times that you can follow those. I'm sure bills are going to get, passed for this. So.
Absolutely. And NAMI is so great about forwarding out advocacy opportunities to go and testify. So we'll definitely make sure that stays front of mind. And I think this just it just reinforces the importance of it in our communities. I have a very quick question that somebody was asking. If your loved one gave you HIPAA permission to talk to your doctors, is there a time frame when it expires?
So the document itself is supposed to say that. And so, if the right language is in there that says it doesn't expire, or then it shouldn't expire. So it's supposed to have a time frame, but you can say it doesn't expire, or you can put in a long time frame, if that makes sense.
Mm-hmm. So it sounds like what we're saying is it's a sort of a case by case. You go in and you look at what the HIPAA document has for that particular organization.
So if you're getting HIPAA forms as part of your estate plan, try to get long period. But I always tell clients that I can't tell them if a particular hospital or a particular doctor is going to accept our form. They should, but they often have their own. And I'm sure you know that when you yourself have checked in, they may have you, sign one. So, but it would be something for you to look at would be, is there a restriction on time and can you modify it?
Absolutely. This is a specific question too. If a loved one is left a house or money as inheritance, they are on SSDI and have state benefits like SNAP or QMB or Medicaid, would the state benefits be impacted? So I think you touched on this, but we'll just revisit that. And then, and what happens to the benefits and inheritance when the person reaches retirement age?
So, let me just talk about retirement age first, because the Medicaid program has so many different types of Medicaid for you to get in. There's the young mothers, there's people that are in nursing homes, there are people that need home care, there are people that are disabled, that just people that don't have money. And so one of the ways that distinguishes these types of programs is age. You have to be between 18 and 64 for this particular program. When you're over 64, 65, then you're on old age assistance and you go through it's a different window. It's not necessarily going to change what you're getting for Medicaid, but it is going to change the window. All of the programs that were mentioned, you can own a house, you can own a car, you won't lose those benefits. There may be concerns over you know, depending upon the Medicaid benefit, if you have money in addition to the house, that may impact your Medicaid eligibility. It would impact supplemental security income, not SSDI, not Medicaid care. And I think SNAP does not look at resources, it only looks at income. So those are good questions, but you know, you really do look at the individual program. And with the Medicaid program itself, when you get a notice, there should be multiple pages on the notice, and one of the pages should tell you what the income limits are and the resource limit. So you should be able to figure this out.
Perfect. And there was a quick back and forth in chat that I just wanted to say out loud as we wind down our last couple of minutes together, where somebody was asking, where do we set up an ABLE account? What documentation is needed? And one of the other participants shared nh.savewithable.com.
Yeah, I actually just looked that up today because that has changed. But if you just Googled New Hampshire ABLE program, you will find it. You don't have to join the New Hampshire program. Every state has a program. You're free to join any program. An interesting fact is that the ABLE programs are modeled after 529 education plans. It's actually a tax law. And so all these states have these, just like they have 529 plans, they now have 529A plans. But it's all done online. You can't do it at a bank. You can't do it with a financial advisor. It's all online. And there are people you can talk to. They're really quite helpful, generally speaking. And you can set up to have checks paid. You can set up to have this, the bank card loaded.
Fantastic. And that brings us to 7 o'clock, which this flew by, and there are still some questions in chat, which what I might do, Anne, if you're willing, I can forward maybe a couple of those over to you as a follow-up after.
Sure. Yep.
But I just really want to say a huge thank you. We covered a lot of ground with some great broad questions, and it was so helpful just to get these initial steps in. I'm so glad that we had the recording on, because we didn't use any names during the exchange. I recorded the whole thing so we can get that back and forth with the questions. And I just want to say thank you, thank you, thank you. And if you're willing, I think we would all love to have you back. I'm seeing already in the chat, can we have her back? Can we have her back? So thank you so much.
Just pick a topic. I can do all trusts. I can do all, I can do public benefits. I can do ABLE accounts. I often do a discussion on how do you have an ABLE account and a special needs trust work together to pay different bills. So.
Awesome. Well, amazing. So incredibly helpful. And thank you so much from all of us at NAMI for giving us this time.
You're very welcome. Take care.
Right. Have a great evening, everyone.
Bye-bye.
Bye-bye.